My assignment for week 3 on this case brief is going to be Culbertson v. Culbertson, and here's the citation. It's 455 Southwestern, 3rd edition, 107, Court of Appeals of Tennessee, 2014. So the background, obviously you can tell by the identical last names that this is a husband and wife and a divorce proceeding, and child custody is a huge contested issue. And the facts were that the wife motioned for release of the records of her husband's mental health, on account of his psychologist, and there were quite a few actually. The Court of Appeals then vacated and remanded after his extraordinary repeal was granted. The following hearing, after remand, the circuit court entered order. The husband's application for extraordinary appeal was granted. So the background of this case, in this appeal, so in 2010, the mother filed complaint for divorce in the Circuit Court of Shelby County in Tennessee. In her complaint, the mother posed allegations for physical and emotional abuse, by the father, not only towards her but the children, in which were very young at the time. The father then answered to the abuse allegations. Of course, he denied it, and he demanded that the mother's complaint have strict legal proof thereof. So later on, the mother said, okay, you want strict legal proof? I'll find strict legal proof. So she requests for the father's psychological records. She wanted pretty much all of the notes the tests, any concerns that the doctor had raised about his mental health. And then he requests for unsupervised parenting time. He said, well, you're not going to get my records, but I'm going to request for unsupervised parenting time. This was denied. He then filed a petition for temporary parenting plan, and I believe this was denied as well within this case. So the trial court then ordered a disclosure of the father's mental health records or mental health status, and the father refused to agree the entry of a proposed protective order because it allowed an expert hired by a party or any person who is noticed for a deposition or otherwise subpoenaed to testify access to the father's psychological records. So that left him, in other words, vulnerable to build the mother's case and to pretty much exhaust his case into nothing. So they weren't able to agree on the language of the proposed protective order. So then he filed for a first extraordinary appeal. The trial was pending, and then the mother petitioned for Rule 35 and the restricted visitation. So this later on goes to the evaluation and the court decision. So she keeps pushing for the records, and the father then agrees to state from a professional psychiatrist that he had been diagnosed, treated, and rehabilitated, and that was enough sufficient evidence to find that, as you can see here, that he was sufficiently stable mentally in the face of the abundance of proof that he has previously been presented to the court to the contrary, and seeking to support that position with now proposed expert testimony from mental health care professionals who have relied in part at least upon opinions and records of his prior treating psychologist and psychiatrist, clearly defines the issue. So he is emotionally and mentally fit, but he was his unsupervised parenting time was deferred. So they just pretty much put a pin in it just in case anything arose from there. So the issue of this case is whether, and I'll scroll back up to the top, is whether the court had, or the mother had the right to the records of of his mental health records, or access to his mental health records. And it did not constitute any viability to that because of the doctor-client privilege confidentiality agreement, as stated in the Tennessee statute that was included in there. And because of this, and because of the child, or what's the best interest for the child when it comes to the mother and the father, because of the allegations were raised, this was also a big issue. So they had to, in some other way, prove whether the father was fit or unfit to visitation or custody or a parenting plan in his favor. They concluded that he was, so that would build a case for the father, not so much the mother, on the abuse claims and the custody battle. So, yeah.